नमस्कार. हॅलो, नमस्कार. आज आपल्या कोल्हापूर जिल्हा बार असोसिएशनमध्ये या व्याख्यानासाठी उपस्थित मुंबई उच्च न्यायालय येथील ज्येष्ठ विधिज्ञ ॲडव्होकेट अभय नेवगी साहेब, तसेच कोल्हापूर जिल्हा बार असोसिएशनचे अध्यक्ष माननीय व्ही आर पाटील साहेब, उपाध्यक्ष टी एस पाडेकर साहेब, महिला प्रतिनिधी मनीषा सातपुते मॅडम, लोकल ऑडिटर प्रमोद दाभाडे, तसेच उपस्थित सर्व ज्येष्ठ महिला आणि ज्युनियर वकील बंधूंनी मित्र, आज आपल्या कोल्हापूर जिल्हा बार असोसिएशनमध्ये आपले बारचे विनंतीस मान देऊन ड्राफ्टिंग प्रॅक्टिस अँड प्रोसिजर ऑफ हायकोर्ट या विषयावर मार्गदर्शन करण्याकरिता मुंबई उच्च न्यायालय येथील नामांकित वकील ॲडव्होकेट अभय नेवगी साहेब आज आपल्यामध्ये उपस्थित आहेत. साहेबांबद्दल थोडक्यात सांगायचं झालं तर ॲडव्होकेट अभय नेवगी साहेबांची सुरुवात काही काळापासून अलीकडच्या काही काळामध्ये कोल्हापूर येथील दिवाणी, फौजदारी, लेबर, इंडस्ट्रियल कोर्ट असे अनेक ट्रायल कोर्ट्समध्ये प्रॅक्टिस साहेबांनी केलेले आहे. आपल्यापैकीच बरेचसे बारचे सिनियर वकील साहेबांना ओळखतात. विशेष बाब म्हणजे साहेबांचे वडील हे जिल्हा न्यायाधीश होते आणि ते आपले कोल्हापूरमधूनच निवृत्त झालेले आहेत. ॲडव्होकेट नेवगी साहेबांचा सर्व्हिस मॅटर्समध्ये चांगला हातखंड व अनुभव आहे. सर्वसाधारण सन 2005 पासून साहेबांनी मुंबई उच्च न्यायालय येथे प्रॅक्टिस सुरू केलेली आहे आणि आजपर्यंत साहेबांना चांगला 40 ते 45 वर्षांचा चांगला एक अनुभव आहे. त्यामुळं असं एक अनुभवी व्यक्तिमत्व आज आपल्याला या व्याख्यानासाठी लाभलेलं आहे. यानंतर मी आपले कोल्हापूर जिल्हा बार असोसिएशनचे अध्यक्ष व्ही आर पाटील साहेब यांना विनंती करतो की आपण नेवगे साहेबांचं स्वागत आणि सत्कार पुष्पगुच्छ घेऊन करावा. त्यानंतर आपण सर्वजण ज्यासाठी आज जमलो आहेत, ज्यांना ऐकण्यासाठी आज जमलो आहेत, मी ॲडव्होकेट अभय नेवगी साहेबांना विनंती करतो की त्यांनी आपल्याला मार्गदर्शन करावं. राजू माईक.
Dear friends, I am really happy to be here on this occasion to address all of you and share what I know about the procedure. Initially, when I started practicing in High Court, there was the advantage of some of the topmost lawyers in High Court, like Atul Setalwad, Iqbal Chagla. So that really helped me. But certainly I was at receiving end number of times as I was not well versed with procedural part. Judges really ripped me off. If when you don't know procedure, why are you practicing here? A senior most judge who he became a Chief Justice of Supreme Court, he said, this is not labor court where you are practicing. This is High Court. So I started taking it really seriously. Worked really hard on it. Still, I can't claim that I know every part of procedure. Honestly, I don't know. And some of you can go to ChatGPT, find out something and ask me a question. Probably I may not be in a position to answer that question. But with this limitation, my team has really worked hard. If you seriously read this note, which is shared in soft format by Santosh, you will not have any problem in Bombay High Court in any bench, including Goa. So please read that. That is a basic requirement. And unless we know basic rules, then like me, you also may be at receiving end. They don't care who you are. They really don't care what is your age, what is your experience. You are from rural area or you have a rural background. Probably your rural background comes in your way and you may end up with bashing. So you need to be very careful with rules. Those are really essential for practice in High Court. As well as any court, any constitutional court. So just to before giving you flavor of rules, I just would like to share with you background of Bombay High Court. Bombay High Court started under Indian High Courts Act 1861. 4 high courts came into existence: Calcutta, Madras, Bombay. 3. Queen Victoria established the high courts, and high court started functioning. The jurisdiction of high court was decided by Britishers. So primarily, there is a difference in one part is a original side, another part is appellate side. Now, why these two are there? Probably a practical approach by some senior lawyer who has penned down in his book is it was to accommodate certain class of creamy lawyers who will have practice confined from Bombay to them. So I don't know. This is a statement I have seen somewhere. So understand that these rules are really important. Bombay High Court initially consisted of Chief Justice and 15 judges. Now that number has gone up like anything. And still there are vacancies. Honestly, sometimes you end up with crossing judge and you don't know he is a High Court judge or even he is a senior most judge. Especially when you are traveling to Delhi, you end up with sitting next to somebody and that somebody happens to be, it's like I was sitting next to Justice Lodha and honestly I forgot, I never thought of he is a Chief Justice sitting next to me. So, number is quite high. Aurangabad also, now Aurangabad bench has more work than Bombay. So Aurangabad court is really busy. Lawyers are now doing very well. Some of the lawyers have earned name for themselves and they are also on judiciary now. They are also functioning as a High Court judges. So Aurangabad is no more a rural bench is what some people used to call. Aurangabad is a really bench has picked up very well. So we also can probably or anywhere anybody can pick up and reach to that level. Bombay High Court has multiple jurisdiction: civil, criminal, admiralty, vice admiralty, testamentary, matrimonial, and again, as I said, original and appellate. Original jurisdiction confines to Mumbai or Greater Mumbai, and appellate is rest of the districts which are part of geographical area of Bombay High Court. Bombay High Court has single judge, division bench, and depending upon situation, there can be 3-judge bench, there can be 5-judge bench. That is a prerogative of Chief Justice. I'll deal with that part also. I am told by Dr. Santosh Shah, Anil Sakhre has dealt with civil part of it. So I will not deal with it much. I will keep my focus on other aspects, especially public interest litigation. Lot of young lawyers, they feel that is a better platform to get name into practice. That is true to some extent, but it can also backfire. One has to be very careful with drafting of petition, following rules. Otherwise, you may get bashing from the court and there may be even heavy cost. Now costs are running into lakhs. So earlier days cost 2,000, 5,000 rupees. Those days are over. Cost runs into lakhs. Now, if you see, Bombay High Court is no more a creation of colonial era. Bombay High Court is a key institution that has developed legal system of the country, and Bombay High Court judgments are respected all over. Even some judgments are referred by even Pakistan High Court and even Pakistan Supreme Court. So Bombay High Court has earned the name, is considered as a number one high court in country. But then there are some controversies. There were some controversies. So probably Bombay High Court lost its charm to some extent. But now again Bombay High Court is bounced back. And Delhi High Court also has picked up. Rather, Delhi High Court, you file petition today and your petition will come up for a hearing next day. That is a system created by Delhi High Court. And they don't give dates. A senior lawyer is not there, keep it back. They say, go ahead. If you are not there, senior is not there, you argue the matter. So that is the best system. And that may come even in other places also. So keep that in mind. High Court over a period has evolved terms of structure, jurisdiction, functioning. But foundational authority under the Letters Patent and Indian High Courts Act remains a significant part of judiciary. It's identity of Bombay High Court. High Court is primarily functioning as a constitution court. It's not of course, High Court has original jurisdiction. Monetary matters in Bombay from original side are with High Court, but that is not the core area. Core area is constitutional law, constitutional matters, and there our judges are they are really fantastic. Their approach, the way they deal with matters is quite impressive. Bombay High Court has a principal seat in Bombay. Then Nagpur is a second seat came into existence for a Vidarbha region. Then Aurangabad came into existence in 1982 and Goa also came into existence around same time. Besides that, Daman, Diu and that area also is with Bombay High Court, and all matters there, they are listed before Bombay High Court. This is within the framework of constitution, and therefore this system is functioning quite well for a long time. Bombay High Court, Goa especially, bench is primarily for Goa, but judges from Bombay also go there by rotation. It's not restricted to only Goa, judges from Goa. Judges from Goa are also conducting work in Bombay. It's like Justice Bobe and even Sonak. They are from Goa. And they are also practicing, they are also discharging constitutional duties in Bombay. This Daman and Diu I have already explained. This geographical distribution is Maharashtra, part of it with Bombay High Court, part of with Aurangabad High Court, part of it with Nagpur High Court. So that is how we work. Bombay High Court has around 11 districts like Mumbai, Kolhapur, Nasik, Pune, Raigad, Ratnagiri and many other districts in the vicinity. Nagpur bench has Akola, Amravati and some other districts again coming within the periphery of primarily Nagpur bench, Nagpur division or Vidarbha division. I think in recent past, not recent past, some years back, in 1982 Aurangabad bench came. Aurangabad bench again Ahmednagar, Aurangabad, Bid, But those districts are also flooding with work in Bombay High Court, Aurangabad bench. So filing in Aurangabad is now picking up so fast. A day will come, Aurangabad will become probably most busy court than Bombay High Court. Aurangabad High Court also got advantage of having jurisdiction of Ahmednagar and Jalgaon. Both are agriculturally and industrially rich districts. So litigation from there is going to Aurangabad from 1988. Each of these benches have jurisdiction over the territory with full authority over civil, criminal, appellate matters, and those matters are heard by single judge as well as division bench, depending upon rules framed by Bombay High Court. So what is crucial is why rules are crucial, as your matter may list before single judge, but then it should have gone to division bench. Then it takes long time, go back to register, go seek circulation again, you may not get. By then you lose your urgency of matter, and you may feel that urgency is lost, you may not get interim order, which is essential for a benefit of your client. Now, appellate side, pecuniary jurisdiction. So, if value is not exceeding 2 crores, jurisdiction goes to appellate side in Bombay in appeal. If it is more than 2 crores, then jurisdiction is decided by division bench, depending upon examining the papers. But mostly it goes to division bench. Then limit ensures lower value appeals are handled efficiently. Everything is planned, worked out in a very systematic manner. So judicial work should not suffer. Judicial work should function better way. So these are the arrangements made by High Court. Rules are updated from time to time. Now distribution of matters, single judge and division bench. Now everybody is curious to know what is single judge and what is division bench. We really don't know which matter will go to single judge or which matter will go to division bench. So let us understand that there are rules. As per Rule 1 of Chapter 1 of the Appellate Side Rules, all matters shall be heard by division bench unless the specific case is specifically assigned to single judge. So which are the matters assigned to single judge is crucial for us. So otherwise, by rule, it looks like all matters can go to division bench, but which matters which are specifically assigned to single judge will go to single judge. Any rule granted by the single judge, matters which go to single judge is expected to grant rule nisi. Rule nisi means it's a preliminary order. He is not going to pass final order. He will pass preliminary order, making returnable, and then it will go to division bench as per the order. Or he may decide to hear that matter by himself. So this particular rule nisi, is really important. To explain it in detail will take some time, but you can now search on Google or even Chat GPT, and you will find out more about rule nisi. Then matters assigned to single judge. Large number of matters from official areas go to single judge. Matters like labor court, industrial service tribunals, matters like some of the appeals under revenue, all those matters go to single judge. Some of the matters, say interim orders under matrimonial acts, also listed before single judge. Delhi board goes up to even 100. So imagine out of 100 matters, when you are going to get chance to argue, get a stay order, quite likely your matter may not reach for a days together. So every time you have to get up and mention, "Hey, my lord, my matter is at so and so." The court may say that, I'll see that, give your precipe. So this particular document is very important. I'll come to that. I have prepared an elaborate note on that, on precipe, because that is essential. You should address that, you should understand that a precipe has an important role. Santosh requested me that better you give some time for a precipe. That is essential for us. Appeals from appellate decrees under CPC or under special local laws, matter goes to single judge. Appeals from orders under section 104 of Order 37, Rule 1 of CPC goes to single judge. Civil revisions go to single judge. Application under Companies Act 1956, application for leave to appeal to Supreme Court under Article 134, transfer application and transfer of suits from one district to another district, one court to another, goes to district judge, but some of the matters also go to single judge, depending upon contents of the matter. Application for appointment or discharge of guardians, application for correction or amendment of pleadings, all those matters go to single judge. Then criminal matters before single judge is a long list. Appeals against conviction where sentence is less than life imprisonment is listed before single judge. Appeals against acquittals where offense is punishable with fine only or imprisonment not exceeding 10 years also is listed before single judge. Applications for bail or anticipatory bail, applications under section 482 of CRPC, now 528 of BNSS, go to single judge except quashing of FIR. Quashing of FIR after amendment of rules now is listed before division bench and is decided by division bench. This is very important for all lawyers to know why division bench and quashing of FIR. Today, that is a really a kind of a goldmine area for lawyers to practice. Criminal law is set in motion, right, left, center, without even finding out whether there is a criminal offense or not. So people rush to High Court for a quashing, and High Court is quite liberal also if you make out a case. Especially somebody tries to convert civil dispute into criminal dispute or a criminal case, Supreme Court has come down very heavily and imposed even a cost. You can see recent judgments by Supreme Court. Supreme Court has come down very heavily. But understand that you should know this quashing jurisdiction, because that is the one area where you will have lot of opportunities to practice. Quashing of FIR also, as I said, goes to division bench. But the most important judgment is judgment of Bhajanlal. That judgment still rules the law, and you should know that judgment. As first question court may ask is, show under 7 which of the category of Bhajanlal your case is covered. If you satisfy the court, then you get relief. If you don't satisfy, you are thrown out of the court. Now, hierarchy of benches. Bombay High Court has been vested with power to issue writs under Article 226 and 227. These powers are part of court's extraordinary jurisdiction and serves as a fundamental means to ensure legal accountability. It empowers the High Court to issue writs for enforcement of fundamental rights as well as for any other purpose. That for any other purpose makes it wide. High Court gets jurisdiction to look into beyond writ jurisdiction. So, therefore, again, this particular aspect need to be examined. We'll have to make out a case that if not covered under this, is covered under any other purpose. Article 227 gives High Court supervisory jurisdiction of all courts. As I have already mentioned, labor court matter, electricity appeals decided by officer, and lot of other matters are listed before single judge. Single judge bench is always busy. Of course, all benches are busy, but single judge benches, you see a lot of young lawyers arguing matters, as they are the one, they get advantage of their early young age, and people prefer to also save some money. So that is where lies the opportunity to go and stand before the court and argue your matter. Once your face is known to the court and is also considered as a person is a studious person, then you will have benefit. Criminal matters before single judge, yes, there are. Appeals against acquittal, appeal against acquittal for offences punishable with fine. There are around 10-12 grounds you can approach single judge. Say like 482, now 528 of BNSS for challenging the orders, criminal orders, except quashing. Quashing goes to division bench. So that is the difference. Then appeals from orders in proceeding under Companies Act, similar statutes. This particular aspect need to be looked into very carefully, as there may be overlapping jurisdiction between NCLT and this particular provision. So now you will have to really look into also IB code. So keep that in mind. You cannot confine to only particular, okay, constitution, I have it, so I know constitution. The answer is no. You need to know what is IB code, provisions of IB code, jurisdiction of NCLT, and even that is a platform you can very well appear from Kolhapur. You don't have to go to Mumbai. It's available online. You can simply log in. You are heard, and I have not gone to NCLT in last 3 years. Appearance is only through online portals. This distinction over judicial efficiency and allocate complex of constitutionality or sensitive matters need to be looked into from another angle. And that is very important, crucial. It's drafting of petitions. Now petitions, there are lawyers, like I have seen a lot of lawyers filing anticipatory bail application, 2 pages. 2 pages application, and they go and argue, they get orders also. They have that ability to put everything in short and then seek order from the court. But in High Court, that may not be possible. But you should not go ahead with a long petition, 40, 50 pages. Then court will say, you come after some time. It has to be to the point. Say 10, 15 pages should be enough, and you should consider approach of the court. Imagine if court has to run through hundreds of pages in a day, then physically is not possible. Physically is not possible. So therefore, keep that in mind. Now, High Court has jurisdiction to issue certain writs. Habeas corpus, I'm sure all of you must have heard, is a commonly used remedy for multiple reasons, and earlier it was restricted to only locate missing persons, but now is used for multiple other reasons also. So is a one area is picking up very fast, and lawyers are also taking advantage of it and approaching High Court for a habeas corpus. And most of the time, if you come out with a case, High Court will entertain you. Most important part of writ jurisdiction is writ of mandamus. If you don't know what is writ of mandamus, then you don't have right to appear in any court, or rather High Court. Mandamus means we command. So High Court commands. So we command. Want certain directions to government authorities. Mandamus is the writ available to you. Then certiorari is a writ to challenge orders passed by subordinate courts. So when you challenge order of labor court or industrial court or electricity duty officer, then it comes under certiorari. Is a writ challenge to order, or say even forest authorities, forest agencies, you can approach under certiorari. That comes under Article 227 and goes before single judge. Single judges are really sometimes liberal also. So that is the one advantage you can always take. Then writ of prohibition. This writ prevents lower court or a tribunal from continuing with proceedings that are beyond its legal authority. Sometimes we see courts are dealing with matter which is not within their jurisdiction. You are telling them every time, and then the court says, I'll see afterwards. But then this writ of prohibition is a remedy available, and you can approach High Court for a relief. Then quo warranto. Quo warranto means by what authority. This is issued to question legal authority of a person occupying a public office. So Commissioner of Municipal Corporation, you can question him, under what authority you are passing these orders. So this is again, these are all powers which are quite wide, and you can deliver justice to people from High Court, which is quicker. But then you need to be particular in following rules. Now, distinction between Article 226 and 227. Article 226 is a original proceeding, meaning thereby it goes to High Court. 227 is a supervisory proceeding, correcting errors apparent on the face of law. So when, say, order of industrial court is challenged before High Court under 227, High Court is expected to examine if there is an error apparent on the face of record. Even if there may be a wrong order, but that wrong order has not resulted into error apparent on the face of law, High Court is required to dispose of that petition or dismiss that petition. So this is the difference between the two. High Court steps into 227 when lower courts have committed errors and those errors need to be rectified. So that is the difference in 226 and 227. Judicial orders of civil courts in some matters are not amenable to writs under Article 226. In such a cases, the remedy lies with single judge under Article 227. As again, 226 division bench is a constitutional court and will look into constitutionality of the matter. Now, question very often argued in court, irrespective of number of judgments by Supreme Court, that is whether a writ can be filed against private parties. So bank, say HDFC Bank or any bank, whether writ can be filed. There is only very, very small scope for filing writ against private individuals. That jurisdiction is very, very narrow, limited. Article 226 or a power of division bench can be used only if the person is statutory authority covered under Article 12. Otherwise there is no question of any private body can be questioned under Article 226 before division bench. There are judgments. Judgment by Binni versus Satsivan is one of the old judgment and frequently used in court. Then criminal matters and distribution of jurisdiction. Just 1 second. Criminal matters, Bombay High Court hears matters both on appellate side through writ petition and includes appeals against convictions or acquittals, revisions, bail applications, applications under Section 482 and now 528 of BNSS. 528 of BNSS and earlier Section 482 is the inherent power. Earlier, under this provision, one used to approach single judge for a quashing of FIR. Rules were amended, I think, in 2010 or 2013, and now it has to go before quashing of FIR has to go before division bench. But otherwise, under even criminal law, jurisdiction is there with single judge. So application for quashing, ordinarily 482 jurisdiction is with single judge. But when you seek 482 for a quashing of FIR, matter goes to division bench. It's not listed before single judge. These are all small things, but you should look into it, read it, and then that will give you advantage. Now, common question is asked about constitution of larger benches. Say matter goes to single judge and single judge is not satisfied with the view of another single judge in identical matter, then he will place the matter before Chief Justice and request for a reference to division bench. Or if required, Chief Justice will have 3-judge bench. So matter will go before division bench mostly, but if serious questions of law are there, then we'll go to more than 3-judge benches also. Same way, there is a matter before division bench. Say a bench is dealing with matter today, and some years back another bench has taken a particular view which is not acceptable to a bench, or they feel that this view is now covered by Supreme Court judgment, and therefore it requires to be reversed. Then again matter goes to Chief Justice, and Chief Justice will constitute 3-judge bench or a higher number of judges there, constitutional bench. So that is how these benches are constituted. where there are conflicting views between different courts, then the remedy is to seek a reference. So may go to division bench if it is a single judge matter, may go to three-judge bench, and may be listed. But that listing takes long time. Some of my matters are pending since 2012. So you can imagine what is the plight of the litigants. If this referring matter to division bench or to three-judge bench should require significant question of law. So it's not only lot of lawyers, they say that this is a significant question of law. Immediately court will question, explain it to us, and if you can't explain, then you had it. So what is that significant question of law? You need to frame it properly with the references, with case law, judgments by Supreme Court, judgments by High Court. Again, unwanted judgments, large number of judgments also creates trouble. You have to be to the point, go with as minimum but to the point judgments and argue your matter. So keep that in mind. Chief Justice is a prerogative of Chief Justice to constitute benches, allot writ petitions, and decide division of work. So Chief Justice will decide. Again, Chief Justice will not decide whether particular matter should be circulated. That is called as an administrative order. You have to go to another authority in High Court, that is Register. So I'll come to that, what Register is expected to do. Then earlier, till 2013, there was a 2013 there was a provision of single judge matters going to division bench in letters patent appeal. This is popularly called as a LPA. But that provision is taken away by High Court by amendment by Maharashtra Act 2008, and remedy of LPA is abolished. Now, single judge orders passed by single judge of the High Court in writ petition or appeal shall be deemed to be validly passed and cannot be challenged before division bench. It has to go to Supreme Court. So you cannot go to division bench. There is a lot of misconception. Lot of lawyers come and they say, this is a single judge order, why can't we go to division bench? To explain them why you can't go to division bench takes a lot of time. So, post-amendment of the law, all single-judge matters or all LPAs were transferred to, before that date, LPAs were filed, transferred to division benches, and those appeals are being heard. Now, most important aspect is listing of matters. How matters are listed. There is a mechanism. Jurisdiction of single judge division bench is decided. So when your matter is listed, you file the matter, registry will ensure it goes to particular judge who has jurisdiction to deal with that matter. So that is an important role by registry. There is again a different type of boards. So one is supplementary board. Supplementary board, mostly matters which are urgent, immediate relief is required, are listed. But to seek a matter on supplementary board, you have to file a precipe and mention it and get early listing. You have to show urgency in the matter. You are saying there is urgency is not enough. You have to really seriously show what is the urgency. So supplementary board is a board for a immediate relief. Besides, then there is a daily board, like what you see in district court and civil judge senior division or junior division. Daily board consists of daily matters which are listed for a hearing. So similar line, this daily board is a board. All matters are listed before High Court for a hearing. Mostly urgent listing, supplementary board is taken first, and then after those matters are over, daily board starts. Sometimes some courts, they put up a time restriction. After 11:30 or 12:30, daily board will start, no matter how many matters are there on supplementary board. Then there is a weekly board. Weekly board has matters which are pending for a long time and which should be decided. Those matters are listed on weekly board. So say 2012, 2014, 16, 18, even 2020, 22, those matters are listed. So there may be a number 305. So that means that number 305 is the number of that matter. It may come, it may not come, but then sometimes suddenly it may come. So you have to be ready with your matters. Once the matter is listed on supplementary board, quite likely it may come for a hearing early, or may not be immediately, but early. Then there is another board which is called as a production board. Suppose somebody is likely to be arrested, or somebody is, his house is being demolished by municipal corporation during rainy season. In such a situation, matters can be mentioned before the court and you can seek urgent relief. Court will instantly put up that matter on production board, means court will decide that matter mostly on same day at 4:30 or at 10:30 at the beginning of the board, depending upon the urgency and procedure set up by the particular bench. So production board is again an important board. Suppose you have a interim relief in your favor and that relief is going to be over today and matter is not listed, then you can seek a production and seek an extension of stay order. So that is what is production board. Then let us come to important aspect, precipe. Now precipe means, it's not a something like a Latin term, it's a simple term which means an order has different meanings across jurisdiction. It refers to simple yet essential document used for communication between advocates and the court. You go before court, you place in short your matter. It's a kind of a letter addressed to court, communication addressed to court through register. My urgency is this. So precipe is the communication, goes from lawyer to court through a register, and expected to be on the letterhead of the advocate. It should be addressed to Protono 3 and Senior Master in case of original side matters. Appellate side matters, it goes to the register. You have to mention cause title, all the and why you are seeking circulation. It has to be a little elaborate, but it should not run into 4 pages, 5 pages. Otherwise, that precipe will become a liability. Register has an important role to play. Now that role is so important, I have to conduct a session for that. So you please read High Court manual and you will find simple way you can find out what is with the technical things. So just now last two important aspects, drafting of petitions. See, every matter in High Court has to be drafted and supported by affidavit. Affidavit has to have elaborate verification. And verification be filed in district court, what I say in para 2 to 4 and 4 to 6. There is a judgment by Justice D.K. Deshmukh, division bench judgment. You can read that judgment. This verification plays very crucial role in filing of the petition. Which are the questions, which are the facts that you will have to place it before the court. And therefore, verification has an important role to play. Then comes statement of facts. You should set out in short what is your cause, what are the facts you are relying upon. One should not make any false statement. If you make any false statement, contradictory statement, then you had it. Judges can easily find out, or other side may find out that and seek a dismissal of your petition. Important aspect which mostly I follow, I also add questions of law in my matter, which some of the lawyers, they don't do that, but I have been following it, questions of law. So immediately you are seeking attention of the court. These are the questions of law addressed in this petition. If you frame it properly, you get immediate circulation or good hearing from the court. You have to disclose in your pleading earlier proceedings, if any, connected with the matter. Either in Supreme Court, District Court, lower court, anywhere. Non-disclosure results into dismissal of your matter with cost. All documents referred in the petition, such as impugn orders, your matter will not get hearing or matter will get delayed and again may result into dismissal also. Election petitions again is an area picking up very fast. Elections are also challenged. Election petitions are mostly go to single judge. And sometimes Chief Justice can allot it to division bench. It mostly goes to single judge. That is the one area which is a good area for a practice, and you need to place on record unfair practices, whatever false statements made by the candidate who got himself elected, or a religious statements made by the elected candidate. All that will be, all that you need to place it on record with supporting paper. This has a provision of evidence, so witnesses also may be examined. Then comes most sought after litigation all over India. Everybody is after this, and that is arbitration. Arbitration is like a printing press. Literally billing of some lawyers run into crores, 2 crores, 3 crores, and international arbitration, it can go to even 10 crores. Even simple arbitration under Arbitration Act, if you see schedule of fees, fees of arbitrators are quite decent. So this is the one area where there is a good scope of practice, but you need to know how to proceed. So Section 11 of Arbitration Act, you can seek appointment of arbitrator, and that has to be filed in High Court. It's a strange provision. Arbitral award can be challenged under 34 before district court. But appointment of arbitrator, one has to go to High Court. I don't know why that anomaly has left. Probably leaving it to district court would have been a better early disposal of the matters. Then Section 9 is a section provides for an interim relief in arbitral matters. Suppose there is a dispute between you and me, and I am taking your goods outside the jurisdiction of the court. You cannot go to civil court because there is a provision of arbitration. So there is a Section 9. So Section 9, you can exhaust that remedy in High Court if you are in original jurisdiction, or in district court in district. Then Section 34 is a challenge to arbitral award. Then Section 37 is there. But this again, arbitral proceedings are not governed by CPC. Arbitral proceedings are governed by principles analogous to CPC. So there is a lot of freedom available, and these opportunities can be used. Recently, a lawyer from Delhi High Court practicing exclusively in arbitration was appointed on, considered as a High Court judge. His annual income tax return showed income of 9 crore rupees. So you can imagine kind of fees he was making. So arbitration is a one area, there is a scope, and you can refer to the rules under the Act. Execution of awards, again, is another important remedy you can really rely upon and execute awards for a recovery. Execution is little difficult, tedious, is more even akin to execution of decree in civil court, but certainly you can consider this also as an opportunity. But then you need to know what is essential and how quickly we can get remedy. Otherwise you may lose chance even after having award in your favor. In the last part of my discussion, I may take some time about it, and that is public interest litigation. Public interest litigation is seen by lawyers, especially young lawyers, as an opportunity to attract attention of people. So you get attention, you get more briefs, you get respect. So that is a one area which is nothing wrong in it if there is a cause. If there is no cause, people suddenly just file public interest litigation, and then you come under a hammer from Supreme Court or a High Court. High Court has considered time and again, you should not file publicity interest litigation. You should file public interest litigation, which should be genuine for a cause. There is a format of public interest litigation. There are certain things you have to mention. You don't have personal interest. How are you going to fund the litigation? Who is going to bear the cost of litigation? So all that has to be mentioned in the petition. That format has to be followed. Without that format, you cannot follow this. You cannot file public interest litigation. But certainly is a remedy. You can give justice to society and also earn name for yourself. But understand that is a double-edged sword. Double-edged sword is Kolhapur toll petition. We got a favorable order from Justice Oak. But when matter went to Supreme Court, Justice Lodha said this order has to go even without hearing us. So you can imagine what happens to public interest litigation. It was a hard time to convince court why this toll has to go. So public interest litigation is an attractive remedy, but then understand that is not for a publicity, is for a cause. And unless you don't have cause, don't go after this. You will end up with trouble. There are rules framed by Bombay High Court specifically for public interest. Every PIL is reviewed by registered judicial, then or protonotary in case of from original side, then senior master. Then this all details such as Aadhaar card, PAN number, occupation, income details will have to be mentioned. And then only petition will be listed for a hearing. You get chance to argue. So public interest litigation is a remedy available, and you can use it and you can take advantage of it. So for the time being, I think I have covered most of the things. Civil law, I have not touched it. I'm almost done now. I'm told I should have 1 hour. I have completed 1 hour. So thank you, everybody. If any questions are there, I'll be happy to answer.
धन्यवाद साहेब. आपण आपल्या व्यस्त कार्यक्रमातून इथं उपस्थित राहून आम्हाला जे मुंबई उच्च न्यायालयामध्ये पिटिशन्स फाईल करताना ड्राफ्टिंग कसं करावं किंवा कोणत्या क्षेत्रामध्ये स्कोप आहे प्रॅक्टिसमध्ये, प्रोसिजर काय आहे, हे जे आपण मार्गदर्शन केलं, ह्याच्यामुळं विशेष करून आमच्यासारख्या युवा पिढीला खूप काही आपल्याकडून शिकण्यासारखं आज मिळालं. त्याबद्दल मी आपले धन्यवाद मानतो. आणि यानंतर मी कोल्हापूर जिल्हा बार असोसिएशनच्या महिला प्रतिनिधी मनीषा सातपुते मॅडम यांना विनंती करतो की त्यांनी आभार प्रदर्शन करावं.
नमस्कार. आज या व्याख्यानासाठी ॲडव्होकेट नेवगी साहेब हे आमचे कोल्हापूर जिल्हा बार असोसिएशनचे विनंतीस मान देऊन उपस्थित राहिले. तसेच आमचे बारला बहुमूल्य असे मार्गदर्शन केले, त्याबद्दल मी त्यांचे कोल्हापूर जिल्हा बार असोसिएशनच्या वतीने आभार मानते. तसेच आपण केलेले मार्गदर्शन हे आम्हाला नक्कीच उपयोगी पडेल याची खात्री आम्हाला आहे. पुन्हा एकदा माननीय ॲडव्होकेट अभय नेवगी साहेब तसेच आपण सर्वजण उपस्थित राहून शांतपणे लेक्चर ऐकले त्याबद्दल आपण सर्वांचे मनापासून आभार मानते आणि माननीय अध्यक्ष साहेब यांच्या परवानगीने कार्यक्रम संपला असे जाहीर करते.